To discuss whether torture is ever morally permissible, and if so, on what grounds, and if not, whether acts of torture can be morally excused after the fact. And our first panelist, I'm pleased to introduce Claudia Card, who's a professor of philosophy at the University of Wisconsin.
Thank you. I'm delighted to be here and learn all of the things that one learns from such wonderful papers. Well, the title of my piece is Ticking Bombs and Interrogations. Torturing to gain information on terrorism is an evil response to terrorism, or so I argue. In my book, The Atrocity Paradigm, I analyzed evils as reasonably foreseeable, intolerable harms produced by culpable wrongs. Reflection on responses to genocide, terrorism, and torture led me since to modify the wrongdoing element of that analysis, substituting inexcusable for culpable. I now define evils as reasonably foreseeable, intolerable harms produced by inexcusable wrongs. Inexcusable here means not just wrong, but indefensible, not even partly justifiable. When a practice such as torture is inexcusable, the norms that define that practice are morally indefensible. It is a separate question whether participants or supporters who apply those norms are at fault for doing so. Their culpability is partly a function of their alternatives at the time and the nature of their participation or support. My concern here is with the morality of the practice of interrogational torture, whether the practice is informal or formalized. As with slavery, and unlike genocide or murder, there is no self-contradiction in supposing that torture might be morally defensible. But the circumstances of its conceivable defensibility are unrealistic in philosophically interesting ways. It is unrealistic to think decision makers can predict when torture will effectively yield vital information, and to think the practice will be containable. It is unwarranted to believe humane alternatives are impossible, and disastrous to reduce motivation to create them. The level of evidence available to interrogators regarding a suspect's identity, knowledge of vital detail, ability to recall it, or reasons for not providing it is unacceptable. It's an unacceptable level of evidence. And finally, the costs of success would negate the gains sought, or so I argue. John Rawls argued that it could have been morally justifiable, or perhaps excusable, to support slavery at a time when slavery was an improvement over the prior practice of slaughtering all the adult males of a conquered people. Enslavement of the conquered enabled future prisoner exchange to everyone's advantage. Slavery was an evil, but tolerating it then, if Rawls was right to suppose it might have been the best realistically available alternative, was not a further evil. Still, Rawls argued, there was a responsibility to work for better alternatives. Perhaps torture could improve over a worse response. It is hard to imagine what worse response might plausibly be thought the only realistically available alternative today. That is not the usual argument of torture proponents, that if the interrogators are not allowed to torture, they will do even worse. The argument is usually that others will do to us something worse. Mass murder, for example. An exception is Alan Dershowitz, who argues that his torture proposal would improve on a worse current practice. I'll return to that. I think the structure of his argument is right and that his concerns are valid, although I don't think his argument succeeds. Torture proponents today often deny that the rough interrogation they support is torture. When torture was not clandestine, people knew what torture was, but today's rough techniques, mock executions, waterboarding, death threats, hooding, isolation, and so on, are not public except when they're exposed as a scandal, as in the case of Abu Ghraib. They need leave no visible scars or even require physical contact, hence a philosophical issue. What does torture mean? Attention to that issue helps reveal what is evil about torture. Current debates are conducted almost entirely from interrogators' perspectives, to the neglect of the interrogated and of the relationship between torturer and tortured. Since interrogators appear to be the only free agents in the case, that might be thought right. Yet the agency of the interrogated should not be neglected. Everyone should read accounts by survivors. One such account is by philosopher Jean Amery. Born in Vienna as Hans Meyer, Amery was captured working for the resistance and tortured by Nazis for information he did not have. Emerging from the Holocaust as Jean Amery, he wrote of his ordeal of the strappado, an invention of the Inquisition. If you've seen the recent film Goya's Ghosts, the strappado is portrayed in that film. In this torture, your hands are tied behind your back, and you are hoisted by them with a rope on a pulley. This dislocates your shoulders, causing excruciating pain. Torture is from the Latin word torquere, which means to twist. Amery quips, what visual instruction in etymology. He was horsewhipped in that position. Yet his focus is not physical pain, but the psychological impact, specifically what he calls one's basic trust in the world. Machiavelli, who's been mentioned by an earlier speaker, not the most trusting man, was also a survivor of the strappado as a young man. That may have something to do with his outlook. A more abstract and analytical essay, also an exception to the neglect of the tortured, is Henry Shue's 1978 essay on torture. That was the year that Amery died. Both Amery and Shue spotlight the relationship between tortured and torturer. Recently, philosophers, unlike politicians, have not lingered over definitions, it's a little surprising, but have focused on the ticking bomb scenario, a hypothetical sketched by Jeremy Bentham in the 19th century, popularized in the 20th by Michael Walzer, and revisited by Alan Dershowitz in the 21st. Could it not be right to torture an uncooperative suspect credibly believed to know the densely populated urban location of a ticking bomb? The danger is imminent, the potential disaster great, potential victims innocent, helpless, and numerous, and the suspect uncooperative. This is usually presented as a one-off case, unique, unprecedented, and not precedent-setting. Yet it is hardly unusual for decision makers to think they confront a ticking bomb. Some bombs tick slowly and softly. In the so-called one-off case, there is implicit a policy. Citing Bentham, who reversed his initial opposition to torture, Dershowitz proposes bringing back legal warrants for torture, for ticking bomb emergencies. His goal is to substitute public accountability to reduce the incidence of what now occurs, as he puts it, below the radar screen, with the participation of governments that officially disavow it. Such warrants would, of course, violate international conventions. If I understand him, Dershowitz agrees that torture is immoral, but thinks regulating it a lesser evil than a ban routinely violated covertly. If interrogational torture is legally regulated, as in former centuries it was, he thinks there will be less torture and fewer fatalities. Thus, the structure of his argument is something like that of Rawls regarding enslavement of the conquered in ancient times. Yet questionable beliefs underlie Dershowitz's proposal. Torture's effectiveness as a tool of interrogation is more dubious than is popularly believed. Recent popular faith in torture rests heavily on its allegedly having foiled a plot to blow up 11 trans-Pacific aircraft in 1995. I believe Dershowitz cites that very case. Yet, historian Alfred McCoy, my colleague in the history department at Wisconsin, who was a specialist on the Philippines and played some role in this movie, Taxi to the Dark Side, cites a Washington Post report that the Manila police obtained all the important information in the first few minutes when they seized Abdul Hakim Murad's laptop, and that most of the supposed details gained from the 67 days of torture that followed were, as one Filipino officer testified in New York, police fabrications that Murad mimed to end the pain. A widely cited case of police torture to find a kidnapped baby, which is reported from New South Wales, concludes that the baby's prognosis was uncertain. We are not told how the torture victim fared. One might object, that's just luck. The baby might have been found in time. Murad's computer might not have had the information, and so on. Yet reliance upon luck is part of the problem. It is doubtful that torture can be confined to extreme situations and not become routine. McCoy cites evidence that to get useful information, it is usually necessary to torture many, most of whom will not or cannot reveal anything very useful. If so, the hope of being able to confine torture to a few extreme cases is unrealistic. In general, it is not predictable who has truly vital information and who will break. The broken say anything, incriminating the innocent, including themselves, whereas the strong prepare to die, making torture in those cases unreliable or worse than useless. McCoy says, and this has been mentioned by other speakers, that FBI interrogators claim persuasion and gaining trust and confidence are far more effective methods to gain truly useful intelligence, though those methods have their own problems. Dershowitz is not the utilitarian many think him. That misperception is based on his lively presentation of the utilitarian case for torture and of the likelihood from informal polls that ticking bomb torture would get popular support on utilitarian grounds. His hope seems to be that by instituting torture warrants, we could secure procedural justice and accountability. But interrogational torture is procedurally a moral disaster. The problem is not preemption. Preemptive interventions can be justifiable. Dershowitz has an interesting book on that, too. The procedural problem is that although torture is more severe than criminal punishments, interrogees have not been found by tolerable standards of evidence guilty of anything. Confessions are poor evidence. Eyewitnesses are unreliable. Torture is the procedure, like the ordeals of earlier eras, by which it is sometimes learned whether an interrogee knows anything vital. Yet, as Henry Shue noted, so-called uncooperative suspects like Amory, who know nothing, have no convincing way to demonstrate that to a torturer. A danger is that the ignorant will be tortured to death by enthusiastic interrogators. Dershowitz's critics, such as Sumas Miller, cite problems of creating a torture culture, complete with torture training schools. Torture cultures are hard to dismantle. Miller and even Shue suggest that nevertheless it might be morally justifiable for individuals, private or official, to defy a torture ban, and that without changing the law, courts might justifiably commute most of the sentence. Miller suggests as a penalty for justified defiers, a day in jail. Although he calls his imagined defiance one-off, Miller's proposal is also a policy, albeit not written into law. Dershowitz's critics appear to disagree with Dershowitz on which is worse, an open torture culture or a subversive one. Something like the problems that Rawls identified 50 years ago with what he called telishing the innocent in extraordinary circumstances burden Miller's proposal for subverting a torture ban. What check, Rawls asked, is there on officials who have authority to telish? What check, we might ask, is there on courts in a population told their lives were made more secure by torture? Would they have access to information adequate to evaluate such decisions, given the practice of classified information? How would they judge whether interrogees were correctly identified? What would prevent judges from retrospectively authorizing torture whenever officials said security required it? Even if courts had access to classified information, how could a public lacking such access be justified in trusting them? If there were much chance that a court would not remit most of the penalty, surely the current clandestine practice would continue. This misnamed one-off solution is no alternative to a torture culture. Interrogators who will be basically forgiven need torture training schools, too. Dershowitz is right to be concerned about clandestine torture. Even if useful information is extracted, interrogees are vulnerable to being pumped and dumped, that is, murdered, as McCoy reports they were in the CIA's Phoenix Project in Vietnam. Information obtained by torture cannot be used for legal convictions, yet victims may appear too dangerous, if only to their torturers, to release. Just as rape victims are vulnerable to being murdered to eliminate the only witness, Even interrogees who reveal nothing may be eliminated to keep them silent about the torture. Dershowitz may hope to terminate that practice by forcing torture to go public, but why would states that covertly violate a torture ban observe a warrant requirement? The Bush administration has focused not on ticking bomb justifications, but on what counts as torture, arguing that the new coercive interrogation methods are merely cruel, inhuman, or degrading, and so should not count. Yet at stake is ultimately the justificational issue. Are the new methods, which depart from historical paradigms like the strappado, enough like the old methods that reasons to ban torture apply to both? Are they comparably evil? The definitional challenge and the more direct justificational challenge to torture in today's debates correspond to the two main elements of an evil on my analysis. President Bush's definitional challenge disputes the idea that his harsh interrogation is intolerably harmful, and so withholds the term torture. In the purely subjective sense, torture is meant to be intolerable. It's in the normative sense, what a decent life or death cannot tolerate, that the definitional challenge disputes the intolerable harmfulness of torture. The more direct justificational challenge is that of Bentham, Walzer, and Dershowitz. It disputes either that an open policy of torture is inexcusably wrong, or that a policy of defying torture bans in extreme circumstances is. And it offers a scenario suggesting possible excuses. So let's look more closely at definitional issues and then return to the apparent excuses, which, if valid, would rebut the charge of evil. The 1948 Universal Declaration of Human Rights says, "No one shall be subjected to torture or to cruel, inhuman, or degrading treatment or punishment." The 1975 UN Declaration Against Torture defines torture as any act by which severe pain or suffering, physical or mental, is intentionally inflicted by a public official on a person for such purposes as obtaining information or a confession, punishing him, or intimidating him or other persons. It does not include pain or suffering arising only from lawful sanctions to the extent consistent with the standard minimum rules for the treatment of prisoners. It adds, torture constitutes an aggravated and deliberate form of cruel, inhuman, or degrading treatment or punishment. In the 1984 UN Convention Against Torture, the following words were deleted: to the extent consistent with the standard minimum rules for the treatment of prisoners. And it concluded simply, it does not include pain or suffering arising only from lawful sanctions. Both documents restrict torture to acts of public officials, although the morally relevant powers can be possessed by others. Within the scope it defines, the Convention rejects torture absolutely. It says, no exceptional circumstances whatsoever, whether a state of war or a threat of war, internal political instability, or any other public emergency may be invoked as a justification of torture. If we abstract from the arbitrary restriction to officials and the arbitrary exclusion of lawful sanctions, the Convention defines torture as a function of intention, pain, and purpose. The Convention's name implies that torture is cruel, inhuman, or degrading. The 1975 Declaration found it also aggravated and deliberate. Do these elements distinguish the new methods from torture? Pain in the specified intent is only pain during interrogation. The new techniques inflict less pain during interrogation than, say, the strappado. But harm from the new as from the old techniques lasts far beyond interrogation and is as severe, if not more so. And it does not ordinarily contribute to the purposes of interrogation. Further, severe pain or suffering, and the Bush administration's benchmark of the pain of organ failure, does not make perspicuous what is serious. Torture is meant to break the interrogee's will. Foreseeably, many emerge as broken human beings, not just temporarily defeated. Threats, humiliations, and mock executions break people as effectively as pain. Amory said pain was not the worst. Destruction of basic trust was worse. Henri Alleg, who was tortured in Algeria by the French, who subjected him to jolts of electricity in fruitless efforts to get information he did have, wrote later, in 1958, in La Question, that he was amazed how much pain he could stand. He thinks when someone breaks, fear, not pain, is what does it. McCoy's chapter on the history of torture takes up two 20th century innovations in breaking people, found through research by psychologists funded by the U.S. government to come up with improved interrogation techniques. One innovation was called self-inflicted suffering. You have to put self-inflicted in quotation marks, which enlists the interrogee's will, as in stress positions. The other was sensory deprivation, as in hooding or severe isolation. If the new techniques are less painful during interrogation than the classic ones, they are comparably stressful. Pain is not always the most effective source of stress. If stress both does the work in interrogation and produces long-range harms incidental to torturers' ends, stress is morally more basic than pain, and a perspicuous definition should substitute stress for pain. Truth serum would still not be torture, however objectionable in other ways. But the other new interrogation methods would be. The advantage of the new methods is that although they are as harmful as the old ones, they are less apt to leave marks, at least the kind that tell tales, which is important to plausible deniability. Stress lasting beyond interrogation is called the aftermath, yet victims experience it as continuous with the torture. Thus, Sister Diana Ortiz, tortured in Guatemala around 1989, says, "One never heals from the torture, but at most learns to cope with the aftermath." But listen to Amaury. "It is still not over," he writes. 22 years later, I am still dangling over the ground by dislocated arms, panting and accusing myself. Worse than pain was his helplessness. At the first blow, he writes, trust in the world breaks down. It's like a rape, a sexual act without the consent of one of the two partners. With the first blow from a policeman's fist against which there can be no defense and which no helping hand will ward off, a part of our life ends and it can never again be revived. Jennifer Harbury summarizes clinical reports on the so-called aftermath as follows. Insomnia, nightmares, flashbacks, chronic anxiety, an inability to trust, self-injury, violent behavior, substance abuse, inability to concentrate, depression, paranoia, guilt, suspicion, memory loss, sexual dysfunction, attempts to numb pain by drug or alcohol abuse, symptoms that can last decades or the rest of a life. This is aftermath only relative to interrogation, not to torture. It is part of what torture in reality is. The Fox TV network serial drama 24, which features interrogational torture, does real victims a disservice by sanitizing torture, presenting victims as bouncing back the next day as though it were no worse than a painful tooth extraction. Were that generally true, torture would not be the atrocity that it is. Yet even revised to say stress, the UN definition of torture is deficient. Injuries incurred in military combat or in self-defense can have the same elements, but are not torture. The distinctive evils of torture emerge when we look at the relationship between the torturer and the victim. According to Henry Shue, what makes torture morally worse than combat injuries is the torture victim's utter defenselessness. Defenselessness aggravates any assault and is central to torture's cruelty. Shue notes, torture begins only after the fight is, for the victim, finished. Only losers are tortured. Now that the torture victim has exhausted all means of defense and is powerless before the victors, a fresh assault begins. In this respect, torture is indeed not analogous to the killing in battle of a healthy and well-armed foe. The one thing the tortured can do, try to appease a torturer, makes them complicit in their own degradation. To overlook how low the tortured can sink in their own eyes, trying to appease those they despise, is to miss torture's blows to hope, trust, and self-respect. The tortured betray themselves and loved ones, becoming complicit in projects they abhor. Orwell got it right in 1984. In Room 101, Winston Smith betrays the person he loved. Unlike Smith, whose capacity for love was degraded into servile attachment, Amaury avoided traumatic bonding to his torturers. Unable to comply, he had no occasion for servile gratitude for rewards. He kept a clear-eyed view of how far ordinary people can degenerate. In 1974, Amaury tried suicide unsuccessfully. He succeeded in 1978, the year after his memoir was reissued, in what he preferred to call a voluntary death. Torture, says Bentham, is where a person is made to suffer any violent pain of body in order to compel him to do something or to desist from doing something, which done or desisted from, the penal application is immediately made to cease. This hedonistic analysis ignores defenselessness and the destruction of hope and trust. Dershowitz, like Bentham, treats torture as physical pain, but torture's most intolerable harm, what the psychologist Leonard Schengold calls it soul murder, does not show up in a calculus of pain. A popular argument is that since pain is temporary and death is forever, killing is worse than torturing, even if the tortured wish for death under torture. That conclusion is not obvious when the aftermath is taken into account. A torturer who kills may do more wrong than one who merely tortures, but the result may not be worse for the victim. To argue that torture is an evil is a philosophical challenge because it requires me to argue for the non-existence of something, namely a plausible excuse. Since I find no self-contradiction in the idea of defensible torture, the remaining strategy is to argue case by case with alleged defenses that their plausibility dissolves under scrutiny. I am in something like the position of John Rawls when he wished to defend his principles of justice over alternatives, but could not be sure that he had thought of all the alternatives. So what he did was consider one by one the most plausible alternatives, given the history of political thought. I cannot think of a better method here. If torture is indefensible, there are no reasonably plausible arguments for it. Yet this is not to say that none are tempting. The ticking bomb scenario suggests 4 tempting excuses. 1, urgency. Humane methods would take too long. 2, relative mercifulness. Torture would actually be less than an uncooperative suspect deserves for being willing to let the bomb detonate. 3, last resort. Kinder methods have failed. And 4, self-defense or defense of the innocent. The objective is eminently worthy, saving innocent lives. Here are some thoughts on each. 1, urgency. The bomb is ticking. But if there is no time for humane methods, there's none for wild goose chases. An interrogee who thought she knew the bomb's location and time remaining would lie about where it was, and shortness of time would help her endure. Were she a collaborator, she would no longer know where. Smart collaborators would move it. Even were she a lone bomber, her say-so is insufficient for others to believe it, nor is the fact that someone looking like her was videotaped, nor that she has a criminal past. An interrogator needs to know that she is who she appears to be now, what she is doing now, and what kind of information she has now. The harsher the treatment, the higher should be the standard of evidence before subjecting anyone to that treatment. Criminal law opts for higher standards than civil law to reduce the likelihood of victimizing the innocent, although higher standards increase the likelihood that the guilty will escape. I defer briefly why that risk should be tolerated in responding to terrorism. One might think torture expedient compared to a courtroom trial, but torture is not always quick. Recall Murad's 67 days. Harbury's husband's death was announced falsely while he was tortured for months. Suppose Oleg is right that fear is what does the work. Pain might be inflicted quickly, but the time to produce effective fear may not be short. Why not use that time to gain a suspect's confidence? Is it that when torture is an option and feelings run high, humane procedures are not attractive to interrogators? If it is unrealistic to expect torture to yield useful results, it is no argument that there is insufficient time for humane methods. The right conclusion may be that there is insufficient time to find the bomb. Torture would not change that, although it might gratify sadism. 2, relative mercy. Since the uncooperative interrogee is complicit in an attempt at mass murder in which victims might suffer before death as severely as from torture, Whereas the interrogator would cause only one or a few pain that need not be fatal, the interrogee deserves, if anything, worse than torture. Could such an interrogee complain? In response, the interrogee is a suspect, not found guilty by tolerable standards of evidence of possessing vital information. Torture might confirm that a suspect has information, but interrogees have no convincing way to demonstrate their ignorance under torture. Where is the mercy for the ignorant? And where is the mercy if many must be tortured to find one who has vital information? If torture is an option, where is the incentive to find humane alternatives? As innocent torture victims accumulate, torture approaches the evil it is supposed to prevent. Further, even if some deserve torture, it does not follow that anyone is entitled to inflict it. Himmler deserved to be starved to death or worked to death, if not beaten to death. It does not follow that a court would have been justified in imposing those penalties. Finally, even if a suspect reveals information, there is so much luck in that outcome that the torture would probably have to be kept secret to avoid general social insecurity. But when torture is secret, history shows the tortured vulnerable to being disappeared, pumped and dumped, as evidence gained by torture is worthless for criminal convictions, but may convince interrogators of the danger of releasing the tortured. Even those who revealed nothing may be perceived as dangerous potential witnesses against torturers. There is no mercy here for torture survivors. The third excuse is last resort, that kinder methods have failed. The suspect has not provided vital information. What kinder methods? Bribes? Beatings? Threats milder than torture? Truth serum? These all appeal, notice, to a suspect's weaknesses or vulnerabilities, and the first three are as likely to elicit lies as truths. Why not appeal to the suspect's strengths? Gain goodwill, build trust and confidence. If such methods fail, there may be no better reason to think torture would succeed than to conclude that the suspect either lacks information or will never reveal it. That a method is the only one left implies nothing about its likelihood of success. Some will think torture worth a try even if success is remote, but suppose it fails. Was it worth the effort? Can a failed torturer have the satisfaction of having tried? Anglican Bishop Joseph Butler noted in his critique of psychological egoism that a failed pursuit of riches leaves only ashes. There is no satisfaction in having tried but failed to get rich. Whereas failed benevolent endeavors or a failed pursuit of justice leaves a partially compensating satisfaction of having tried. Wouldn't failed torture leave worse than ashes? All that suffering for nothing. Of course, if a bomb detonates, there will be real ashes, but we don't know there is a bomb, when or whether it will detonate, and in any case, why add to the ashes? Finally, self-defense or defense of the innocent. The objective is worthy. But how innocent are we if we defend ourselves by torture? This argument begs that question. Is a nation that cannot defend itself without torture worth preserving? Self-defense is not always an acceptable excuse for individuals. If it is objected that the proposal is not to torture a suspect's children or parents, even if that were more effective, a response is that torturing many innocent to find one who knows something vital is no better. Why think that whatever is necessary for self-defense is any more defensible for a nation than for an individual? Aristotle held that some acts perhaps we cannot be forced to do, but ought rather to face death after the most fearful sufferings. Some betrayals, he thinks, are such that one should die first. Are there not also deeds that nations should face the most fearful sufferings rather than do? Interrogational torture is a good candidate, right up there with war rape, which is another form of torture, and genocide. Empirical arguments that highlight torture's ineffectiveness and uncontainability should persuade realists that torture is not realistic. Procedural arguments highlight torture's injustice, yet those arguments skirt the moral heart of the matter. The core evil of torture is its betrayal of humanity in both the tortured and the torturer. Amaury refers to destruction of basic trust in the world Even if actual trust does not altogether disappear, torture destroys trustworthiness. That loss negates the hoped-for gain of protecting society and saving lives. It means the risk of letting some who really do have information about terrorism escape from insisting on high standards of evidence is a cost worth bearing. For where is the value in a society or a life in which trustworthiness is lost? How could a nation defended by torture, especially torture forgiven by the courts, be worthy of the trust of its citizens? What clandestine or hypocritical practices would such a government not support in the name of self-defense?
Thank you. And now, Marcia Barron, professor of philosophy at Indiana University, will discuss the ticking time bomb hypothetical.
Thank you. I want to quickly begin by thanking Scott and Martha for organizing this and for inviting me to this conference. I've been certainly engaged by this topic for a number of years, as I hope most thinking people have, in this country in particular, but I hadn't ever written on the topic, and I'm glad that this occasion prompted me to work on it. I may not have made it as clear in my paper as I should have that I wrote this in order to address something that I found puzzling as I was reading the literature on torture. So I'm trying to sort something out. I'm not sure if I figured it out, but maybe that'll be something you can help me on. Recent literature arguing for or reaffirming the impermissibility of torture has deplored the ticking bomb hypothetical and its frequent invocation. I have in mind in particular Bob Brecher, Claudia Card, David Lubin, and Henry Shue. I share their views by and large, but at the same time think that just what is so problematic about the hypothetical remains to some extent unclear. I hope to bring out more sharply just how the ongoing focus on the ticking bomb hypothetical and the revived torture debates has led us astray. We probably are all reasonably clear on what's meant by the ticking bomb hypothetical, but to be sure we're on the same page, I want to start by quoting Henry Shue's presentation of it in his classic 1978 article, Torture. There is a standard philosopher's example, he says, which someone always invokes. Suppose a fanatic, perfectly willing to die rather than collaborate in the thwarting of his own scheme, has set a hidden nuclear device to explode in the heart of Paris. There is no time to evacuate. The only hope of preventing tragedy is to torture the perpetrator, find the device, and deactivate it. Now, to be fair to the defenders of torture, I'll quote a version they put forward. This is from Mirgo Bogaric and Julie Clark from their book, Torture, When the Unthinkable is Morally Permissible. A terrorist network has activated a large bomb on one of hundreds of commercial planes carrying more than 300 passengers that are flying somewhere in the world at any point in time. The bomb is set to explode in 30 minutes. The leader of the terrorist organization announces this via statement on the internet. He states that the bomb was planted by one of his colleagues at one of the major airports in the world in the past few hours. No details are provided regarding the location of the plane where the bomb is located. Unbeknownst to him, he was under police surveillance and is immediately apprehended by police. The terrorist leader refuses to answer any police questions, declaring that the passengers must die and will shortly. The conclusion, as Bogaric and Clark see it, is clear. They ask, who would deny that all possible means should be used to extract the details of the plane and the location of the bomb? So just what is problematic about the hypothetical? Doesn't it test our intuitions, getting us to question our commitment to a principle that torture is always...
And the things we can know are, at least absent a providential God such, that it can never be the most reasonable thing to do as a form of self-defense, and that we can't know that to whatever degree of epistemic certainty, short of maybe, absolute certainty, which we may not be able to have about any matter of fact, can be met. I may be still bewitched by the ticking bomb here. Although I'm sorry, I'm departing from my remarks here. The case that seems more compelling to me, and the sort of thing that I have in the back of my mind, isn't a hypothetical but an actual, although I fear people here may know more about this than I do. But the sort of thing that, say, happened in a case in Germany a few years ago, in which a 9-year-old boy was kidnapped. This may be like the case Claudia referred to in Wales?
New South Wales.
New South Wales, sorry. 9-year-old boy was kidnapped. The kidnapper was caught. It turned out to be his tutor. The man had the marked ransom money that was picked up, right? He didn't pretend that he wasn't the kidnapper, right? But he wouldn't reveal where this boy was, hoping to allow him to die, right? His body wouldn't be found. The case couldn't proceed against him, right? Time was of the essence here, and there wasn't time to develop some kind of bond with this person. The German police captain threatened to torture this man, right? I'm going to assume that threatening to torture someone is of a moral class of torturing them, right? It's an incipient form of torture. That might be challenged. He threatened to torture this man, and indeed it worked, right? He revealed the location of this boy who unfortunately had already been killed, right? Question was this German police captain wrong to do what he did, right? And it seems to me, no. What he did was not only morally permissible, I think it was morally obligatory. Right? Despite the sorts of risks and real considerations that have been put on play here, nevertheless, given the structure of the situation, this seemed to me not merely permissible but obligatory. It worked as much as anything could have worked there. There was not a wave of torture that swept over Germany as a result of this. A grim situation, but I just can't imagine. It seems to me cases like that are much more interesting than the ticking bomb one. Now, it may be the case that there are important differences of fact here that I'm missing, because I don't know this case super well. But I do believe what I've set out is at least true. Okay, sorry, that was actually not what I wanted to talk about. Because I wanted not actually to talk about the question of absolute prohibition right off the bat, but rather just say a few words about trying to understand what the objection to torture is in the first place, what the anxiety is, and hence what the logic of the considerations relevant to thinking about it is. And in particular, I'd like to frame this in terms of an intuition that Tom Nagel, in the article War and Massacre more than 30 years ago, when he sets forth the distinction between what he calls dirty and clean fighting, which he does set out to defend certain absolutist prohibitions, is onto something right about how to think of these cases, although I don't think it ultimately supports any sort of categorical prohibition. It does, I think, show why the justifications for torture are extremely narrow, even more narrow than other kinds of self-defense justifications. And those are the kinds of justifications I'm interested in here, forms of self-defense, the fifth of Claudia's options. Okay, so according to Nagel, so I'm just going to have to talk a bit about Nagel here. That's always a good thing. According to Nagel, to fight dirty rather than to fight clean is, and this is a quotation, to direct one's hostility or aggression not at its proper object, but at a peripheral target which may be more vulnerable and through which the proper object can be attacked indirectly. And this is the quote. Clean fighting, in contrast, is some sort of violence or some sort of action directed immediately against that about your enemy, which is actively and wrongfully directed against you. Right? Nagel here asks us to consider hostility as a personal relation in which fighting needs to be guided not just by a sense of its effectiveness towards a just end. This is very far away from a sort of a consequentialist framing that often moves in here. For Nagel, proper fighting must be guided by something like an expressive function. That is, it must serve as a kind of reply, a counter to the wrongful intent or action of another, rather than just a piece of physical opposition. Right? And as Nagel says, this is another quotation, whatever one does to another person intentionally must be aimed at him as a subject with the intention that he receive it as a subject. It should manifest an attitude to him rather than just to the situation. And he should be able to recognize it and identify himself as its object. Now, I realize that this may sound overly intellectualized or morally precious or just hopelessly obscure. But I think there's something just right here, if we can sort of unpack it. Nagel's thought seems to be that in fighting someone, even to the death, that this is much closer to arguing with him than we would normally acknowledge. That is, there is some sort of implicit norm of address that needs to be honored if fighting another person is going to be morally different from dealing with some other kind of physical threat. Nagel sort of packs this out, or tries to illustrate this with another, I think, fairly effective example here. He says, in an altercation with a taxi driver over an excessive fare, it is inappropriate to taunt him about his accent, flatten one of his tires, or smear chewing gum on his windshield. And it remains inappropriate even if he casts aspersions on your race, politics, or religion, or dumps the contents of your suitcase into the street. Okay. For Nagel, to fight guided by this idea of replying to and not just harming your opponent, to fight in this way, one must strive to direct one's attacks against what is specifically tied up in the expression of wrongful intent, rather than against something like the general features of human life and concern in this opponent that bear no such special connection. I may fight to disarm, say, or to disable. Of course, the only way to do this often is to kill, and in such cases, Nagel thinks that killing can be appropriate. The sort of thing that is prohibited is attacking the enemy's general humanity. In those cases where it is something that can indeed be distinguished from the provocative activity. Even in contexts in which I might be permitted to kill my enemy, it may still be wrong to attack him through what he loves, his children, his church, his orchards, even though doing so may be able to effectively distract or disable him. For Nagel, the use of chemical and biological warfare, or attempts to starve an enemy into submission, or to keep him from medical care, are supposed to be objectionable for these reasons, even in contexts where we are otherwise entitled to kill our opponent. Okay. Now, I confess the distinction that Nagel is going after here is hard to make precise. Nagel himself goes on to argue that the use of napalm is wrong, categorically, because of the way that it is directed against, as it were, the humanity, the life of the sinner, rather than the sin. But Nagel does think you can sometimes, at least in warfare, kill with bullets and bombs. It's a little hard to see exactly what the meaningful difference is. And this, I think, can lead people to suspect that Nagel's real objection to napalm that he's misrepresenting here is simply the horribleness of being burned to death, right? Supposedly worse, much worse than being shot or blown to bits. It's true, but maybe, right? And now it just sounds like this distinction between countering or replying to an enemy's wrongful act and striking at his person as a substrate of his agency is really just a way of sort of puffing up a much more simple and direct objection to something on grounds of cruelty. Right? And I think that's what's happened in the napalm case. And I think in general the distinction that Nagel's putting forth here isn't the sort of thing that can, in principle, be made sharp in lots of cases. There's just going to be a lot of irreducible indeterminacy here. And that may limit the usefulness of the distinction. But at least for the issue of torture, I don't think there's any indeterminacy. Right? Torture and this will include many forms of harsh interrogation, torture light, whatever it's being called these days, right? That wide scope of things that the Bush administration hacks like to quibble over. This is going to be a fairly capacious category. That these things are going to count, I don't know if they count as torture, but they'll count as dirty fighting, if anything counts as dirty fighting. Right? In torture, we do not, and such things, we do not attempt to directly block or frustrate the wrongful actions or intentions of our foe, but instead to exploit the perfectly general vulnerabilities and concerns that our enemy has as a human being, which we know how to exploit precisely because we share such vulnerabilities and concerns with him. Right? A perversion of solidarity, you might say. The loves, fears, and vulnerabilities we take aim at are things that would be what they are, right? And such that our torture would be equally effective even if our enemy had never dreamt of attacking us in any way or were engaged in such things. They are what they are, independent of what this person is doing. Okay. That's a distinction. The question is now, why attacking someone through their feelings, emotions, and body this way fails to address them as a subject, which is the central notion, that it necessarily fails to address them as a subject, and hence, in a way, that it could be received of on their end as a subject. Now, Nagel addresses the question of torture, but I think his answer here is not terribly helpful. Right? For Nagel, supposedly, we see that we cannot really be addressing our foe as a subject in torture when we realize how ludicrous it would be to even attempt to justify our actions to him. Nagel says, quotation, "One could even say, as one bayonets an enemy soldier, it's either you or me. But one cannot really say while torturing a prisoner, you understand, I have to pull out your fingernails because it is absolutely essential that we have the names of your Confederates. Nor can one say to the victims of Hiroshima, you understand, we have to incinerate you to provide the Japanese government with incentive to surrender." Okay, that's the quotation. Now, I think the problem with this sort of reflective exercise is that it's going to be question-begging. I think it does indeed sound ludicrous to address these sorts of justifications to the torture victim. But that might just be because we already think that torture is uniquely and categorically wrong. So it begs the question there. And in any event, there's always going to be something bizarre about imagining oneself as offering some justification to people who you are about to derange with pain or burn to death, right? How could anyone be expected to listen to such justifications or take them seriously given what they are about to experience, right? Given what these situations would normally have to be like, any such appeal, particularly if prefaced with the condescending, you understand, would seem to be a mockery of the victim. And this need not be because the appeals do not actually advance good justifications that a reasonable agent should accept. Rather, such appeals may seem ludicrous simply because in any conceivable instance of such a situation, it would be insane to ask one's victim to think about his predicament reasonably. I think the intuitions that Nagel is appealing to here are just terribly overdetermined to tell us anything. Now, of course, we might imagine ourselves addressing ourselves to our foe at some distance from an actual altercation. We might imagine ourselves as good contractualists drawing up common principles for proper fighting in advance of any particular conflict, or under some sort of veil of ignorance or other deliberative mechanism meant to keep us from identifying exclusively with one party in these imagined scenarios. But once one does this, I think, it is now no longer so clear that we could never address a justification for torture in good faith to the one who would be tortured. Torture does, as Nagel notes, target aspects of its victim that have nothing to do with his wrongful acts or intentions, and so is presumptively a case of dirty fighting, presumptively wrong. The question, however, is whether we may fight dirty, or what would otherwise be dirty, if this is the only way to resist dirty fighting. Terrorism, like torture, I think is presumptively dirty, aiming at the soft targets of an enemy's ordinary life, his basic concerns and sensitivities as a human individual or a human member of a human community. And surely these facts about what, say, terrorism involves must make some difference as what would count as a proper reply to his action meant for him to receive as a subject. If the terrorist strikes at us through what we care most intimately about, and we strike at him through his most intimate concerns, just as a way of frustrating his attempt, assuming there are no decent options, why isn't this sort of reply the sort of reply that we recognize as a taste of one's own medicine? Right? As Claudia said, how could the terrorist here object in both consistency and good faith? So here I think the thought here is pretty simple. We might think that a general principle of reciprocity governs self-defense. The thought here is that for any kind of wrong, I offer this as a true moral principle. I can think of no counterexamples to this. The thought here is that for any kind of wrong, I may commit, or presumptive wrong, let that just be presumptively wrong thing. For any kind of presumptively wrong action, I may commit that wrong against someone if this is the only effective way of frustrating this person's attempt to commit that very sort of wrong against me or those for whom I am responsible. Absent better, reasonably effective alternatives, of course, a lot can hide under reasonably effective, right? But absent better, reasonably effective alternatives, I may kill the person trying to kill me, assault the person trying to beat me, or steal from someone if this is necessary to keep him from robbing me. I mean, I suppose I could, right, there's a tale of a bank robber who comes in, puts a gun, points a gun at a bank teller, asks for money, the teller gives him the money, he picks up the bag, the teller picks up the gun that he had put down in the apple, right? He stole the robber's gun, right? I assume that was actually the robber's gun. Is this permissible? Of course, right? I suppose if you can imagine a context in which, one to frustrate a rape, to rape the would-be, I mean, just can't imagine how it would work, right? But I'm sure there are people who can dream this up, and were such a case actually to occur, I think rape in that case would be justified. I think that's just a completely general principle. And moreover, it seems that within a certain range, one may commit what is normally a greater wrong against a would-be assailant in order to frustrate the wrong he is trying to commit against me. I think one may kill a would-be rapist, if, again, that's the only realistic form of resistance, and do a fair bit of violence to a would-be thief. Right? I'm not sure exactly what the range is, but I don't think strict equality is required here. I don't think you can kill people who are trying to, steal minor things from you. And it seems approached in a contractualist way, the justification of these sorts of principles is pretty clear. For an assailant here to object to such forms of resistance, for these people to be entitled to resist him in these ways, he would have to be asking other people to care more about his rights and interests than they are being allowed to care about their own, and more than he cares about their rights and interests, right? That's insane. If the assailant wishes not to become exposed to such treatment from his intended victims, he always has the power of simply not starting things, right? The victim, in contrast, doesn't have the power of not starting things, right? He finds himself put in the situation not of his choice, and you would think then he is entitled to a certain degree of freedom that he otherwise would not have to extricate himself from that situation. Since the assailant has control over whether the conflict, the whole situation gets going in the first place, I think his victim is entitled to special powers of resistance against him insofar as he is, after all, the one who has created and is sustaining the conflict. Okay. Now, it might be thought that while this general principle of reciprocity does normally govern matters of self-defense, it cannot apply in the case of torture because of the special asymmetry that torture involves. This is a point Henry Shue made quite a while ago. A person might indeed kill the person who is trying to kill him, or wound the person who is trying to maim him, but one could never be in a position where you could torture the person who is trying to torture you. Right? The thought here is that, as Henry Shue argued, that one can torture a person only if he is absolutely helpless before you, that is, if he is at your mercy. But it would seem that this relation, the relation of being at someone's mercy, is necessarily irreflexive. If I am at your mercy, you cannot be at mine. Right? That would mean then that if I'm in a position to torture this person at all as a causal matter, right, he cannot be in a position to torture me, and so the special self-defensive justification cannot come into play at all. That's just a peculiarity about torture, right, because of the asymmetry it involves. Now, I think something like this is true, or is pretty plausible, if we were only considering sort of two isolated parties who do not have dependents or confederates, right? This is an idealization. But normally, we think that principles of self-defense apply not only in such contexts to people considered as sort of atomistic individuals, but also with respect to those to who I have an obligation to protect, right, and with respect to those I act with in concert. So, suppose, here's a hypothetical, and it's completely underdescribed, but time is short. Suppose a terrorist group has captured and is torturing one of my children. How do I know they're torturing one of my children? They're putting it on the internet, okay? That is, any sort of doubt, we can tell the story to neutralize any sort of epistemic problem here. So they are torturing one of my children. But we have also just captured the leader of the group, right, whose orders my child is being tortured at the behest of, right? He has directed this. Question, may I torture him if this is the only effective way of getting him to reveal where this all is going on, and so to stop the torture that is proceeding under his orders, right? That is, in a way, his act. In one sense, my captive here is at my mercy, but nevertheless, he still has power to act against something dear to me through his subordinates who are acting under his command, right? In a case like this, seems like a case where we're in a way both at each other's mercy, right? It seems to me in a case like that, I can offer a justification. I can offer a justification for torture that, I can offer him a justification for torture that were he able to think about the situation dispassionately, he could not reasonably reject. Right? So long as my thinking about what to do is conditioned by this sort of reflection, holds itself to the standard, it seems that in cases like this, torture is indeed consistent with addressing my enemy as a fellow subject, despite its normal dirtiness. This sort of justification would then, in principle, seem to be available to torture those who are engaged in terrorist acts, if we see terrorism, as I think we should, as something of basically the same class of wrong as torture. Could argue about that, but I think they're in the same moral ballpark, right? The justification here would not extend to anything needed to prevent a terrorist act or to anyone who is in a position, right, to make that possible. So far, I have only argued something much weaker, that we may torture to frustrate an act of terrorism already in progress if it is done against those who have set this act in motion and are in the process of carrying the act to completion. That's a very narrow class of things. I'm sure one would have to meet a very high epistemic burden if the situation satisfied that, but again, I have no reason to be confident, absent faith in a providential God, that that burden could never be met. And in the case, I think it was Jan Meyer, in the German case I mentioned, it seemed to me the epistemic standard was met. Okay. Now, I'm try to finish up quickly. I do want, so that's it seems to me torture can be justified as self-defense in this very, very narrow way. But I do think there is something special about torture in that it may not allow for the wider principle of self-defense. Right? I had argued on the narrow principle, I may kill the person trying to kill me if that's needed to prevent him from killing me. Right? A wider principle would say, maybe I'm entitled to kill the person trying to rape me, right, in order to frustrate that act. Right? That there's a certain, you might think, leeway in terms of self-defense. I suspect that wider application doesn't apply to torture. That is, that torture can be justified on the very narrow principle of reciprocity and self-defense, but not in the wider version. And I'm going to have to make this point much too quickly because I mistimed things. But it's that it seems to me essential, part of what it is to address a combatant as a subject and do all this stuff, is to leave open the possibility of restored or reconciled or the creation of decent moral relations, right, afterwards. Right? Justice after war, as Kant talks about it. And torture, I think, unlike other types of hard ways you may fight against someone, is the sort of thing that generally puts a moral impediment to the possibility of reconciliation, whether or not it's justified. The impediment I have in mind is not just that it's psychologically difficult for torture victims to in any way enter into relations of trust, openness, respect, civility with their tormentors. I'm sure that's true as a psychological matter, although I'm also sure it's true that some people have actually managed to do this. People can do anything. Sorry, that's all I know about what people can do. My point is, it seems to me, having the experience of oneself as limitlessly dependent, vulnerable, and exposed to another person, right, in the way torture involves, is the sort of thing that would make any future trust you had in that person, any future openness, any future respect, not just psychologically difficult, but morally objectionable. Because no one could engage in that without always having the suspicion that in some way you were reenacting that relationship, reenacting that subordination. The very attitudes that look like moral progress, trust, reconciliation, are in this context the sort of thing that could be the profoundest violations of basic duties of self-respect. Torture, then, unlike other forms of very hard ways you might have to defend yourself against someone, puts a moral and not just psychological block to restored moral relations. And I'm almost done. And that sort of thing, I think, makes it bear a special burden of justification, even with respect to self-defense, that killing doesn't, that maiming doesn't, that many, many other things don't do. Right? Maybe some other things fall into this class. Rape, I take it, would fall into this class, but maybe that's because rape is a subcategory of torture. Right? In that case, the self-defensive justification seems to me most plausibly limited to stopping either attempts at torture itself or whatever its moral equivalents are, and it seems to me its moral equivalents are a very narrow class, although there probably are a few other things there. Okay, I'm done.
Well, we have time for some questions now. I did just want to add my little factoid of knowledge about the German case that was mentioned, which was, I think the threat was, the detective said, we have a specialist coming in from Dusseldorf. And that was apparently enough to get the guy to crack. There was no specialist coming in from Dusseldorf, but I believe that the detective was nonetheless disciplined for having threatened torture, even though it did reveal the location, although as it turned out, the location of the dead child. And with that, let's take some questions. Yes, you raised your hand first.
Thank you. I think that it's problematic to try to get the ticking bomb example out of the torture debate by focusing on uncertainties, epistemic problems, probabilities, and so on. Let me suggest why. You can raise exactly the same problems about self-defense or defense of others. Suppose that some notorious child murderer and rapist or whatever has escaped from prison, John Wayne Gacy, to take a local example from the past. Suppose he's escaped from prison. You get a number of independent reports from people saying, hey, phoning into the police. We just, John Wayne Gacy's picture was all over the news for a long period of time, so everybody's familiar with what he looked like. Imagine all kinds of people phoning in. We've seen this man in prison outfit running into the park. And police go to the park, and they see in the distance a man in a prison outfit pointing a gun at a child. And they've got a problem. What should they do? They've got a marksman there who can just shoot this man at a distance. Well, take that example as a case of defense of the innocent, and you can raise all the same kinds of doubts. How can the police be absolutely sure this is John Wayne Gacy? How can they know he won't change his mind at the last minute, repent of what he's doing and go give himself in? How can they really know that the gun is loaded? It might be an unloaded gun. It might be just threatening the child in this way with an empty gun. Shouldn't you try other means before you try to kill him? Shouldn't you try to approach him and talk to him and so on? I mean, there's some probability that he's going to kill the child in the intervening time. Suppose the police do try to shoot him, and all they do is merely wound him, and he kills the child anyway. And suppose these are long-lasting injuries that are inflicted by the wound, so that what we've done is we've caused this person long-term suffering for nothing. We didn't manage to save the child. Now, these are the kind of doubts that people raise of an empirical sort against the ticking bomb example. They seem to me to work equally well in this kind of case, but I don't think that anybody would really say that in cases of defense of the innocent, you just can't do it because there are all these uncertainties. You have to just go up to the man and try to befriend him or something like that.
I would say you just can't do it. I think those are very serious problems for the use of marksmen by police. 60 Minutes had a very interesting program on that very issue once. Marksmen are trained to shoot at a target very carefully, but they're not trained to make the kind of judgments that are involved in this kind of case. It's setting him up to be a judge and an executioner. I think all the things that you just described are excellent reasons for not using marksmen that way. And the only alternative isn't to go up and try to be friends with the guy.
Can I just say, what if it's not a marksman? You could take the self-defense, defense of others case of somebody is breaking into your house, and there's lots of epistemic uncertainty about what they're exactly planning to do. But the law, so you don't have a marksman sort of make, okay, now I will kill him, but you just have someone reacting to the situation where they think that their lives or the lives of other people in their house are in danger. But there's lots of uncertainty, and the law does not require that you be certain. I mean, the law might be morally wrong here, but it doesn't require that you be certain in order to use deadly force to protect yourself. And I just see the marksman case as an extension of that. It just happens to be the public authorities, but it wouldn't have to be the public authorities. I mean, what do you think? Because the point you made about lack of process, we have no process by which we have engaged to determine the facts, and yet we're inflicting on the person a punishment worse than anything we can inflict. That is also true about all sorts of use of defensive force. People do not have a process, they kill, and then the process comes later.
Yeah, well, I think the two things are actually related, the process and what it is that you're inflicting. And killing someone in self-defense, I think, is not as bad as torturing a person. When you're inflicting something much worse, I think, when you inflict torture on someone than when you simply take their life, take them out, shoot them. People who are being tortured would much rather have somebody take them out like that rather quickly. We require a higher standard of evidence when you're going to do something much worse to a person in order to be sure that you're doing it for the reasons that you think you are. And I don't think that case, that's like Henry Shue pointing out that in war and in self-defense you may inflict physical harms just as bad as the harms that are inflicted in torture. But the relationship between the parties is very different. It's not the same kind of a relationship.
G-Day?
I have a quick question. One is the moral grounds, like this is sort of an external critique question, which is if you ask maybe a social scientist and economist, why do certain states not torture? They may say it's not in their self-interest to do so. It's not a moral transition argument. So if the British did not torture the Argentines at Falklands, because it would serve their interests even as a military strategy to do so. There are many, many ways they can get information in a conventional war scarcity rather than torturing the Argentines in Falklands. When you throw the question back on the French in Algeria, that's unconventional warfare. And if we see a trait where the moral argument against torture is only observed in the breach, every time you have unconventional warfare, where there are insurrections, most states that are trying to squash insurrection engage in unconventional means to deal with the situation. Don't you now have to ask the question, what is it about unconventional warfare? It's just the argument about torture now says, let's use it against Al-Qaeda. It doesn't say when we engage another state in war, in conventional warfare, we should use it. What is it about unconventional warfare that draws this out? And is there something rational about states not wanting to do it in one area and thinking that it's permissible in another area, even if it's in the breach? And I think the general philosophical argument does not address these two categories.
Well, I think it's helpless.
Well,
Torture was used in Germany. Americans tortured POWs in Germany. None of them can say it's a conventional. So I'm not sure it's the right description.
well, I'm not sure about the right description, but it seems to me what's morally salient maybe about the non-conventional cases is that the kind of asymmetry here is the sort of thing that defeats normal relations of reciprocity, right? And you might think, I mean, I do think, that a lot of moral thinking has to involve relationships of reciprocity. And so one could understand how, when you're facing foes who are willing to acknowledge reciprocal commitment limitations, if you'll acknowledge them and there's some prospect of sort of ongoing interactions in which your roles will be reversed with respect to one another, that focuses people appropriately on what's morally salient. Where when you're dealing with contexts where, because of power, right, those expectations and those ways of thinking aren't salient, then it's not surprising that distinctively moral forms of reasoning don't gain the same kind of purchase, and then become maybe more vulnerable to certain kinds of prudential or non-moral sorts of temptation.
Eric?
Yeah, I'm struck in the first two talks about how much of the arguments seem to rely on empirical claims, which may very well be correct, but strike me as highly uncertain. And I just wanted to ask one or both of the first speakers whether their arguments are essentially empirical. That is, they just think that torture never works, or it works so rarely that, it's justified to have a flat ban. But of course, what would follow from that is that if we obtained more information, if it came out that showed that it did actually work, they would change their minds and become enthusiastic defenders of torture. Let me just give a couple examples, just some things I wrote down that people said. If you torture the victim, the person being interrogated, you might not know where the collaborator is. That's an empirical claim. There might not be enough time to use the information. You might make errors and end up torturing lots of people who either don't know anything or are able to withstand the torture and not give information. If you have torture, that will reduce the government, presumably, the government's incentive to find humane alternatives. One claim was that torture has to be secret, otherwise, if it becomes known that it's going on, it will result in social insecurity. And then another similar claim that torture is difficult to contain. So these all sound like just empirical claims, which again could well be true, but just to ask, suppose the Israelis, who we know have been engaging in torture for quite a long time and have studied it, and there's a commission, but suppose they went farther and they said, okay, here's all our data, these are the people we tortured, here are the bomb plots that we thought that we foiled. You can look at everything you want, you can do it, and you get a bunch of neutral people, social scientists, to go and look at all this information. And it turns out that in fact, they saved a lot of lives. Is your claim that so there are two possible points, and I'm just asking which is it? Is it that even if this were true, you'd still think it's wrong for the Israelis or anyone else ever to torture? Or are you willing to say that if in fact this study is done carefully enough, and it turns out that lots of lives were saved and there weren't humane alternatives that were practical and so forth, then fine, you would be in favor of torture?
I'll speak to that, I guess. Is this working?
Yes.
Yeah. I guess I just want to say that there are a lot of other features that would have to be in place besides that it, in fact, worked in a particular instance. You'd want to know how many people needed to be tortured before you got the information that you needed. You'd want to make sure that there weren't, say, 1,000 people tortured in order to get one bit of information where maybe 800 of those people who were tortured weren't. I don't rule out the kind of thing that Henry Shue said in his earlier paper, right? He recanted in the later paper. In a later paper in 2005, he basically said that he was too generous in the direction of allowing torture might sometime be permitted, and that he should have taken a more complete abolitionist view that it's absolutely out of the question. I can't with exact details in terms of whether it was the scenario could not possibly happen, or that even if it did, we shouldn't torture. It seems to me that if you had the kind of very hygienic sort of torture he was envisioning when he's talking about it in the first paper, people are given anesthetics, they're brought back to full health and released back into their homes, et cetera. It's more like a surgery. It's very brief, completely different from the practice as we know it and it's always been. Then you might have an argument that it could be like self-defense. But this goes back to Jeff McMahon's question. The practice of torture is a practice, and it's very different from what goes on with individuals using force in self-defense. There doesn't seem to be anything infectious about that. It doesn't seem that you do it once and you want to do it as often as you can now, or that you want to ratchet it up, or that you want to get a job where you can use force against people. At least from what I've read, I've done some work on self-defense, there doesn't seem to be a tendency that way. So self-defense doesn't have some of the features that torture has because of the fact that torture has to be done as a practice. Now, if you want to imagine something completely different with torture so that it's not a practice, then I don't rule out the possibility, Claudia might, I'm not sure. I wouldn't rule out the possibility that it could have the status of self-defense. But I don't think it's irrelevant to look at all these empirical details. And I don't think they're just the way torture happens to be at the moment.
I would like to add something to that. I think that it's not self-contradictory to suppose that under some imaginable conditions, torture might be justifiable. I don't think the ones you described would be good enough. You say you save a lot of people by what price did you pay to save them? But what I'd need to be convinced by is that torture is a better alternative than something worse that we would have done otherwise, that the torturer would have done. The argument that's usually offered is a different one. It's more like, I think, what David was suggesting, that if we don't do it, they'll do something worse to us. I would like to see something like the Rawlsian argument about slavery, that it's somehow that torture is an improvement over even worse practices that we would otherwise have engaged in. And I haven't seen a convincing case of that yet.
What about an argument that if a nuclear bomb goes off in an American city, that the response that will occur will be far worse for lots more people? That is, not the people who are killed in the bomb, but the response will be rounding up large scales of population and interning them and so forth. And so this is better than that.
It's hard to know whether that's another hypothetical that I could.
I think that
they
we
could
keep
fill out
getting-
in a plausible
We
way.
also
Yeah.
keep getting back to comparing self-defense to torture, which I think is a really important thing to do. In fact, I almost wrote my paper on that because it's, I think, a very pressing question of what makes them different. But the connection between shooting somebody and getting them to stop shooting somebody else is very much closer, much tighter connection than torturing them to get information, which then you can utilize in time to defuse the bomb. So you've got something quite different going on, and you're having to imagine that you cannot accomplish things differently. Anyway, I won't keep going because we have a lot of questions.
I will say, as a matter of law, you can shoot someone to stop things other than them shooting you, such as...
Sure you can.
There's not a complete...
Sure you can. No, I don't mean the connection in terms of the action being done. I mean that shooting will stop them. It really will do it. But torturing them may do nothing, and usually doesn't.
Well, you may
Shooting
miss.
may feel
You may
so.
miss, but Kim.
Yeah, first of all three of these papers are wonderful. It's hard to make progress in a crowded field, and all three of these papers say something new. But in many ways, all three papers reproduce what strikes me as being one of the real problems of the hypothetical itself. And that is the hypothetical is posed as a matter of personal morality. Would I do this in these circumstances? Whereas I think the question that is the more empirically realistic question is, should a country do this? Right? Which is to say, should we have institutions that do this, rules of engagement, people trained to do it, which is a very different question than the spontaneous, personal, potentially brave person who might act. Second part of a question is, even assuming you're in the situation where you have either a lone, brave, moral soul trying to decide whether to do this or not, or an institutional setting in which there are sort of rules laid out under which such a practice could be done, if you have a case like a nuclear weapon in New York and the person's in New York with the potential terrorist trying to make this interrogation, one of the other things that we know, it may be a contingently empirical matter, but it would say something about whether you would ever have the kind of judgment in a situation that everyone is counting on. If you yourself as the potential interrogator are also going to get blown up by this weapon, and you have to decide whether to make the choice or not, or it's your child, as you say, what we know about those kinds of situations is that people who are themselves terrified are very bad at applying rules and making rational judgments. And so these are two different kinds of attacks on the general kind of approach that you're taking. One is the institutional one, one is whether anyone can make a judgment if they themselves are likely to be also hit by the very thing that's a threat.
Me?
So, well, actually, all three of you could answer it, but whoever wants to start.
Well, let me just comment about. I certainly agree there are two different questions. There's an institutional one, there's an individual one. I don't understand why one is more, I think you said empirically realistic than empirically real than another. This German police captain, right, sometimes we have to make decisions as individuals and not simply as actors in roles defined by institutions. There may be some deep tensions between the norms that bind us as occupants of those roles and just as human beings. But I don't think that displaces or makes the other question somehow irrelevant or makes these questions logically unconnected. I just didn't understand. I recognize they're different questions, and the answer to one doesn't settle the other, although I take it there might be logical contact there. And I wasn't saying anything, by the way, about whether there should be, police should generally have a recognized power to do this, or this should be institutionalized in any way. Here I think the sorts of empirical anxieties that have come up are determinative. The second part, I just wasn't talking about that. The second part of the question was, admittedly, if your child's life is on the line, you're not going to think clearly. On the other hand, you have to make a decision either way. It's not as if, I'm sorry, I can't make this call, so we're just going to sit around and look at this guy in the interrogation room for a few hours. That's making a call too, right? I take it, if the situation, it would make sense for me to say, you may find someone else to make the decision, but at some point, someone has to make the decision, right? And it may be one that you can't hand off, and in which case, you know, you do the best you can. It would seem bizarre to say, I'm sorry, my child's life is on the line, I'm deranged, I can't, you know, even take an educated guess here. There are deep moral costs either way. That's one problem I have, I think, with some of the way this gets set up, is it gets talked as if there's a moral cost on one end if we torture, but there's no moral risk on the other end. I think the moral risk in the ticking bomb case is we allow our Confederates, people who we have obligations to protect, to be incinerated. That's not just a bad consequence, that's a failing in one's duty. The pressure comes on both sides, and I think not on just one.
Susan?
I think this is another way of thinking about what Kim raised. I'm not sure, and maybe this is directed mostly at Marcia and Claudia, why we're concerned about state of mind. I mean, isn't part of the problem exactly in Thomas Nagel's definition that we're focusing on hostility and we're focusing on the expressive intent of the act? If we want to make a moral absolutist argument about torture, why does torture have to be something that's done for a particular purpose and not for another purpose, as opposed to why not just say these sorts of practices are simply off the board? Once you start looking at the purpose for which it's done, isn't that when you start opening up the empirical questions that Eric raises, the ticking time bomb exigency, the question of state of mind, which is where I would argue that torture and self-defense are not the same? That if you say torture is something that by definition is wrong as a matter of practice, not as a matter of state of mind, then we just should not do it. And you know, and that would distinguish it from something like self-defense, where we really do care about why somebody kills somebody, that there might be reasons why it's okay. So why is purpose and intent always part of the definition of torture, I guess is my question.
Can I respond?
Yeah, go ahead.
Yeah. See, I don't think you can show that torture is by definition wrong. I've tried. I wish I could. That would be a much neater, quicker argument. I think that I can't think of a purpose that justifies it either. But that's not my argument, as the gentleman in the back pointed out, is not a priori. It's empirical, largely empirical. And in the same way that Marcia takes apart the ticking bomb case, by the time you grant all of the hypotheticals, all of the things you're supposed to suppose, you've got a case that's very unrealistic. Take the German baby case. David Sussman said it worked. It didn't work. It didn't save the baby. All it did was it got evidence so that you could convict the murderer of the baby. Is torture a permissible, let alone obligatory way to gain evidence to convict a murderer? No, I don't think so.
I may have maybe I wasn't clear in my question. I was saying we shouldn't be having that conversation at all if we say this type of practice is simply never okay as a moral absolute. The sorts of things that happened at Abu Ghraib should not be done. Once you start getting into the empirical issues, once you start getting into intent, why did you do this? Did you do it to get information? Or did you do it to
you could do that if you could show that, like murder and genocide, they're wrong by definition. But I think that torture is like slavery. Slavery isn't wrong by definition, but I think it's wrong. And likewise, torture, I think, is wrong, but not by definition. I wish I could show by definition that it was wrong, but I haven't been able to do that. That's why you get into these other complexities.
Scott? You had your hand up?
Yeah. I'll ask Kim's question, first question, just a slightly different way. What moral difference does it make if it's a state engaged in torture rather than an individual, if any? That's for anybody who'd like to address it.
I actually liked her way of phrasing it, so I'm not sure if I'm answering your phrasing or her phrasing as well, but let me just get back to her comment. Basically, I liked her way of putting it because it seems to me that captures one of the huge differences between between torture and self-defense. Torture is a state issue. It requires a lot of things to be in place. It doesn't make a lot of sense to ask, what would you do in this situation? What do you think should be done? Because that supposes that somehow it doesn't involve anything else that has to be behind it. self-defense, in fact, is like that, right? You don't need to have this kind of apparatus in place for it. So I think that is very useful to draw that distinction between the two, and it highlights the fact that torture is a practice. And it has huge rippling effects and so forth.
Make this the last question.
Yeah, last question. Yeah.
This is to David. As I understand it, the way you justify the circumstances in which you see torture is possibly justified are when the person to be tortured has done something egregiously immoral or is on the verge of doing something egregiously immoral. You'll correct me. And possesses agency such that they can undo what they've done. And those two conditions mean that, for instance, you couldn't torture a third party in order to induce the terrorist to reveal information. If the agency part, I just wanted to see if you could say a little bit more about, because one might have thought that in the process of engaging in the business of torturing the terrorist is in a way trying to get to a point where his agency is so reduced that he'll yield up the information, that he won't even really, he's trying to reach a point in breaking him down so that he's no longer fully an agent. It sounds as if at that moment on your analysis, torture is no longer permitted.
Oh, no, it's still permitted.
Well, but then I've clearly misunderstood what the features are about the person to be tortured that make it okay for the torture to go on. It seems as if you wanted to preserve a fairly robust notion of agency, agent-to-agent relationship, and it looks to me as if, in fact, in the very process of torture, you're going to destroy that.
That's true, although that might be the case in self-defense, right? Where you have to kill in self-defense.
No, I don't mean that you'll destroy it for the future, but that the moment at which...
But not only, I'll just say quickly, because I...
Yeah. Is yielded is one where the person is literally almost...
The person is no longer an agent, but what justifies it and overrides the normal objection to that is that is necessary to annul the act they are engaged in. And generally, if there's a wrongful act that is directed against you, I'm arguing you are permitted to do what is necessary to annul the act. If it turns out that that's necessary to either destroy the agent by killing or by dissolving the agent, as torture does, both of those things become derivatively justified. But the focal question is what is necessary to counter the act rather than prevent a bad consequence or something like that.
All right, we're out of time, so let's thank the panel.